आज मैं बोलूंगा कि 300 साल पहले मेरे दादा की जमीन थी और मुझे अभी ये हक चाहिए, तो मेरे को कोर्ट 2 मिनट में बाहर उड़ा देती है. आई विल नॉट कॉमेंट ऑन द कोर्ट डिसीजन, बट आई एग्री कि अयोध्या का जो डिसीजन, ये मेरा पर्सनल व्यू है, जो जजमेंट हुआ है उसके ऊपर कॉमेंट करना इसमें कोई गलत नहीं है. अकॉर्डिंग टू मी वो एक समझौता उन्होंने निकाला है वो जजमेंट में, लेकिन माना गया है कि आइडॉल्स आपने जबरदस्ती घुसाए 1949 में. या बनाने वाले कारागिर ये हिंदू रहते तो कोई कुछ बना सकता है उधर बनाते समय. तो ये बातें कॉन्क्लूसिव नहीं है. और मैं जैसा मैंने बोला, मैं बोलता हूं ये भी छोड़ो, अगर हक बनाया भी है तो आज क्या आपको हक मिलता है क्या कि वो तोड़ो.
इस फोरम के चीफ कन्वेनर जस्टिस अभय थिप्से साहब को विनती करता हूं कि वो अपने ख्यालात आपके सामने रखें.
2 lawyers have spoken before me. They have explained the legal issues. Usually the lawyers who used to argue before me, they used to have opposing views, but today we don't have opposing views, and nor do I pronounce a judgment today. Father also expressed his concerns which touched legal aspects but more of social aspects. Maulana जी ने भी बताया, उन्होंने कुछ इशू रेज किए. मैं समझता हूँ ये तो एक इसमें सोशल डायमेंशंस आर मोर इम्पोर्टेंट. Legal aspects are important only to understand the nature of controversy so that you can form effective opinions. However, I would add a word of caution. When a matter is pending before the courts, we have to make the comments very guardedly. We can't pronounce a judgment. In the sense, we can't say that if this is decided, it will be wrong. We can't pronounce that. That is... that's not considered as proper or ethical. So we can give our views. These views are undoubtedly very sound, and maybe they will be canvassed before the court. What Rizwan Merchant said, these views, I am sure they will be canvassed before the Supreme Court, because it is not finally decided. Supreme Court is bound to take a decision on those issues finally. Whatever a judge says at the initial stages, that is not a decision of the court. I have been a judge for 30 years at various different levels. And I know that these opinions sometimes change after you hear both the sides. These offhand opinions. So, of course, these are very weighty arguments. I fully agree with them. These arguments, I am sure, will be presented before the Supreme Court, and we will have a very sound and reasoned decision. Now, I will go step by step. First of all, I would like to explain about the sedition. What are my views? These are also my views. Those who are not conversant with the legal process, they may not be aware of the intricacies of the judicial process when legislation is challenged before a court of law. In our system of democracy, we have permitted the court's interference in a legislation which is passed by the parliament. Parliament is supposed to be sovereign. It passes the laws. But in our country, the constitution is supreme, not parliament. And what the parliament is doing, if it violates the constitutional provisions, the courts can interfere and strike down the law. This is called, as you must be aware, that the court declares the law as unconstitutional. So that is permissible under our constitution, and even the high courts can do that. High courts and Supreme Courts are clothed with such powers to declare a particular law to be unconstitutional on the ground that it violates some of the provisions of the Constitution. But what happens many times, a law, the court is not willing to strike it down for whatever reasons. So it adds certain words in that or omits certain words from that statute and tries to interpret it. No, it means like this, and then it is okay. This is a sort of via media which the court adopts. Court says, no, what you say is correct, it should not be like this, but what it means is this. This is called as reading down commonly. Some words are omitted or some words are added. Unfortunately, if you see sedition law, there have been many cases after the constitution came into being, Because this law, as you know, IPC itself is old. This was introduced later, but it was during the British time. And actually, I have always said, and it is my view, that we speak half-heartedly. We speak of the misuse of the law. I don't agree with that. It is only use of the law. The law is meant for that only. Law is meant to curb that. The agencies are not doing anything different. Because the law was brought for that. It doesn't require violence. It says by any means, some of the clauses which I saw the text, creating disaffection. But disaffection doesn't, it is short of hatred also. Disaffection doesn't actually, may not go to the extent of hatred. But the wording is or excites or attempts to excite disaffection towards the government established by law. Now let us see, what was the position at that time? They had that act, British Parliament's Act was there which made it legitimate. They took the power from the East India Company and the British monarch. That rule was there. So that was the government established by law, that was their stand. And if you create disaffection towards that government, then it would amount to that offense. And many people, including Tilak, I think Maulana Azad also, Gandhi also, many have suffered imprisonment on this section. It doesn't require violence. But when this challenge came after the constitution, it was argued that this law is not valid. But the Supreme Court at that time, instead of taking a great step of declaring it as invalid or ultra-vires, said no. It means that only if the incitement is such, which is not written there. Let us understand that it will lead to disorder, public, some violence, and these requirements are put by them just because they did not want to set it aside. Now, according to me, a good opportunity was missed by the Supreme Court to be true to the Constitution. But anyway, those times were different, what weighed in the minds of their lordship. But I say that these type of guidelines, that it should be, if it is of a degree, this degree, then only you invoke, that again leaves the matter vague. Again, it is to be decided by whom? By the agencies only. So how can you prevent the so-called misuse? I call it use only. I always said that these laws are not misuse. They are used because they are enacted with that object only. TADA was enacted with the object of whatever may happen in the trial, the person should remain in custody. Many of the draconian MCOC Act I have dealt with for 7 years. I don't think anybody has dealt for a longer time than that with MCOC Act. It is basically the provisions are, if the public prosecutor opposes, you keep him inside. Make some unreasonable test which the court has to satisfy before releasing a person on bail. And this is what is causing problem. The courts are not striking it down. They are just saying, no, it means like this. And this is what has affected this. Now, I am sure that this sedition law is not required at all. And I go a step further. Of course, this is not a legal debate. Means I am not speaking before a legal forum. Otherwise, one can have that discussion also. If violence is required as a part of sedition, as they said, or that degree of, then there is a separate offence under the IPC, that waging war against the state. Then it will become the same. It will become redundant if you require. So sedition actually meant for that only. You speak bad about government, people will be have disaffection towards the government. This government is bad. If such type of feeling you try to create, then the law will be applicable. And Tilak and all that were penalized for that only. So that is a separate aspect. Now, I think it would be examined. Now, it is another principle of jurisprudence that when validity of a statute is challenged, the court cannot stay the operation of the statute because it is passed by the parliament. So, in this case, what the Supreme Court has very properly done is that they have taken an assurance from the Solicitor General who represents the Union of India that it needs reconsideration, and I am sure that they would be reconsidering, and all the facets of the controversy would be properly put before them. Nobody doubts their legal acumen and capability, and an appropriate decision on the touchstone of these constitutional provisions will be taken by them. That is one aspect. But see, the problem we have, Mr. Merchant said about UAPA. Now, I have no hope that this will change the situation in any way, because I think in many cases where 124A, that is sedition, is applied, UAPA is also applied, and there is nothing about UAPA. UAPA is worse than 124A. It is worse, absolutely worse, and made still worse by some interpretations of the Supreme Court recent. I am told that thereafter one or two judgments have been passed by one of the by a judge, bench headed by one of the newly appointed judges, and they are better, but I have had no occasion to see them. Might have been diluted to certain extent, the rigors of some other judgment. But what will happen to UAPA? Now, as a result of this, the trial, if UAPA charge is there, going by what the courts are doing and by practical experience, I think Mr. Merchant will know better. But they will say that yes, 124A is there, but UAPA is there, so I can't release him on bail because I have to fulfill the requirements for release on bail, which are very stringent in UAPA. So this difficulty will come, and therefore there should be a challenge to UAPA also. And many challenges have been given; they have failed. I think we need to raise this challenge. Yeah, some challenge is pending. I am told. Yeah, many earlier have been turned down also. But I think UAPA and this has to be considered together. UAPA is worse, more draconian, more difficult to get bail under. So today, only because there will be reconsideration of the provisions regarding sedition on the constitutional touchstone, we need not be very jubilant unless and until the same task is done with respect to the provisions of UAPA. I am told that, of course, that it is pending, and we hope that it would be decided in the true spirit of the Constitution. Reading down many times doesn't help, because you dilute it, and then it is left to the investigating officer to ascertain the gravity, because then you only make a difference of degrees. And degree, who decides that is not the accused, but the investigating agency. So those who are familiar with their way of writing remand applications and all that, I do not say more. I mean, every small case, they bring some international conspiracy where they don't want, person to be released on bail, big gang, some foreign countries' names, ramifications, international, national. So these things happen. So that is one aspect. Now, yes, of course, Mr. Merchant has very competently explained the various provisions. I also fully agree that this object of many of these draconian laws is to detain without trial. Detain without trial. They don't want to go on trial because many times there is no evidence. And they have made, in some statutes, they have made the confession made before a police officer admissible. So apart from that confession, there is nothing in those cases. In many of the cases I have seen. But the fear and atmosphere which is created is such that people are afraid of arguing also, even sometimes to their full capacity they don't argue also, looking to the vehemence of the public prosecutor. I don't know, Mr. Merchant must be aware of that. When I was sitting as a single judge in the High Court, 5 times Advocate General appeared before me in bail matters, which is very rare. Advocate General appears on the instructions of government only. And before a single judge 5 times appearance means there was nothing in those matters, but they were worried, and this happened only in my court. I don't know, he will put it before. I don't know before any other court he has appeared for opposing a bail application. But they would know that what questions I will be raising, because our views are known to the advocates. In fact, there is a philosophy for every judge, and your orders speak for themselves. So going by that trend, they might have said. What I mean to say is that the appearance of Advocate General in a bail matter is to create a fear. To show the seriousness, to show how serious the government is, and how careful you must be in doing whatever you do. Just please remember, the sort of this. These tactics should not work in the court, but unfortunately they do sometimes work. Because as every person is different, some people's nature, they differ. If a man is not brave, he doesn't become brave by becoming a judge. Or, it happens, that basic, then also it's a matter of confidence in your knowledge. That also matters. that you are sure of what you are doing. So all these issues, we will only conclude, we will not discuss what the Supreme Court ought to do, such discussion. But it's a good that a relook to those provisions will be. Now, as far as Gyanwapi case is concerned, there also the matter is pending. We should not go very much deeper into that and what ought to be there. But of course, the provisions of that act have been read, and design of some party that is also explained, that how to take it outside the purview of that 1991 act. That of course will be argued before the Supreme Court, and I am sure that the Lordships will take a considered decision. They will be ably assisted by both the sides. One thing is there about the social aspects also, as I fully agree with Father, and I will add also, when I was in Jalgaon district as a principal district judge, I had come across a person, and when I came to the High Court, we are permitted to take one person as who is called as co-terminus. He is our employee till we are in the High Court. He was from a Bhil community, which is in that Khandesh. And of course, I trained him so much that today he speaks English also. But he tells to my wife, so many things he told to my wife, because they can't directly, that sort of respect they maintain, they don't tell us. So many things, all their professions we have made offenses. That were their traditional professions are all offenses. They are all prohibited by law. Without providing them any alternate, profession or alternative way out, how to survive. You stop them by saying that you can't do that. What they used to do, take sand, sell it, prepare this country liquor from these flowers. All these are offenses, Wood can't be cut, forest wood. They are living there only. They are born there. So how they will survive if these are the offenses? But when we made these offenses, we should have thought of their survival, how to provide income to them, how they will earn their livelihood. That has not been done. So these people cannot think that this is their government. So of course they are the original people of this country that way. Even Aryans came subsequently. There is now a claim that Aryans originated here only, which is not acceptable to history. Aryans, maybe after 30 years, they will be able to sell this also, that Aryans came here. But today they are trying. But it needs time. Aryans came from outside. We know that Mohenjo-daro, Harappa culture was, but before that it was not an Aryan culture. We don't know whether Aryans destroyed that culture or not, that we don't know, because the destruction, how it occurred, we don't know. Let us confess about that. But see, the question is not that. I agree, Maulana Sahab ne bola ki wahan nahi tha temple. I don't want to go into that. सवाल ये है कि conquerors जो होते हैं, वो conquerors after conquering some area need to subdue people, और उसके लिए कभी कुछ उनको करना पड़ता है, नहीं तो revolt हो जाता है. These are done by conquerors, not by a particular religion. When जब उन्होंने राज किया, तभी ऐसा नहीं किया कि एक पर्टिकुलर कम्युनिटी को ये मौका दिया या ये लाइसेंस दिया कि आप दूसरे कम्युनिटी के लोगों को मारो और कुछ नहीं होगा. अगर ऐसा होता तो ये हिंदुस्तान ऐसा रहता नहीं था, क्योंकि मुगल रूल तो 800 साल था, उसके पहले भी इस्लामिक रूल था. तो ये बात तो है उसमें, लेकिन मैं उससे ज्यादा महत्वपूर्ण बात ये कहता हूं कि क्या आज आपको तोड़ सकते हैं. उस टाइम समझो, जैसे अब बाबरी का भी इशू खत्म हो गया है, बिकॉज ऑफ जजमेंट खत्म हो गया है, लेकिन समझो कोई मंदिर तोड़ के कोई मुस्लिम रूलर ने उधर मॉस्क बनाई, और वो मुस्लिम रूलर को अगर हिंदू राजा ने उस टाइम हराया उसके बाद, और फिर वो मस्जिद तोड़ के वो फिर मंदिर बना सकता था, वो समझो ठीक है. लेकिन क्या आज ये परमिसिबल है? आज क्या वो हिंदू राजा जीत गए? आज क्या हो गए? वो जो मस्जिद बनी वो मुस्लिम रूलर थे उस टाइम, उसने after succeeding in the war he might have demolished it, but many of the mandirs are kept intact. Like Abdul Khan came, he destroyed Tuljapur Bhavani's mandir when he came to attack Shivaji, but it was very much standing there for so many years. Adil Shah did not do that. जब वॉर होता है तो वॉर के रीजन अलग रहते हैं. तो सवाल वो नहीं है, लेकिन सवाल क्या है कि अब 1947 में जब भारत स्वतंत्र हुआ तब एक नया राष्ट्र पैदा हो गया। आप क्या ऐसा सोचते हैं कि वो जो ब्रिटिश आए थे उस वक्त जो राज था वही फिर से आ गया, ब्रिटिश चले गए और हमारा पहले का सब था? ये सब यही सोचना, मुझे माफ कर दिए, ये बेवकूफ़ी है मैं कहूँगा। 300 से ज़्यादा प्रिंसली स्टेट्स थे जब ब्रिटिश आए थे, नवाब्स थे। हाँ, ये तो मुझे करेक्ट कर रहे हैं, 500 या 500, बट 300 इज द सेफेस्ट विच आई हैड रेड समवेयर। उसमें हिंदू रूलर्स थे, मुस्लिम नवाब्स थे। इनका जो सब राज था उसमें डेमोक्रेसी नहीं थी, रूल ऑफ लॉ भी नहीं था, हर एक के कानून भी अलग थे टू अ ग्रेट एक्सटेंट। जो कंट्रोल था वो ब्रिटिश लोगों का कंट्रोल था, ऑन द कॉन्ट्री। इनफैक्ट इंडिया एज ए यूनाइटेड वन नेशन ये ब्रिटिश रूल में फर्स्ट फील हुआ। तो ये जो बातें, ये जो देश पैदा हुआ ये कॉन्स्टिट्यूशन से हुआ। कॉन्स्टिट्यूशन आई बाद में, लेकिन 47 में हम फ्री हो गए और तब से कॉन्स्टिट्यूशन ढूंढते थे। अल्टीमेटली वो 50 में अडॉप्ट कर ली हम लोगों ने। अब सवाल यह है कि ये कॉन्स्टिट्यूशन के बाद ये जो देश आया भारत, ये जो नया अपना देश है, ये क्या आपने मुस्लिम एम्परर से छुड़ा लिया और आज आजाद कर लिया और जो उन्होंने जाति किया थी वो उसको हम आज रिपेयर करेंगे, ऐसा है क्या? ये सबसे अहम मुद्दा है। तो आप ये कॉन्स्टिट्यूशन के लिए क्यों तैयार हो गए? ये हमने खुद को दी है। अभी एक सेक्शन ऐसा है जिनको एक कॉन्स्टिट्यूशन पसंद नहीं है, लेकिन वो ओपनली बोल नहीं सकते। आज ये राज आपने मुस्लिम रूलर से छीना नहीं है, तो एक नया ब्रिटिश रूलर से भी नहीं छीना है, जो गए फिर भी आपने वो इंडिया एस्टेब्लिश नहीं किया जो उन्होंने लिया था। आपने एक नया इंडिया एस्टेब्लिश किया है, जिसके नए कानून है, जिसमें आपके जो बिलीफ्स है उसका आपको यू हैव अ राइट टू मेंटेन योर बिलीफ्स, रिलीजियस बिलीफ्स, फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, ये सब जो है। तो इसमें ये मुद्दा कैसे आता है? एक्सेप्ट कि आपको झगड़ा करने के लिए, झगड़ा कुछ निकालना चाहते हैं कि यहाँ ये था, ताकि आप उसके खिलाफ उठे, अशांतता पैदा हो, प्रोग्रेस ना हो सोसाइटी का। मैं यूरोप में भी गया हूँ, यूरोप में भी मैंने देखा है कॉन्करर्स तो डिस्ट्रॉय करते थे, मतलब चर्चेस के ऊपर मस्जिद है, मस्जिद के ऊपर चर्चेस है। मैंने स्पेन में देखा है, मैंने टर्की में देखा है, ये होता था। लेकिन आज वो लोग ये मांग नहीं कर रहे कि ये तोड़ो और उस पर कुछ बनाओ। ये तब थी जब राजाओं की लड़ाई चालू थी। अभी ये उनका बैड लक है कि वो नहीं जीत पाए, और उस जमाने में उनको हरा के वो फिर से तोड़ के फिर मंदिर एस्टेब्लिश कर सकते थे। वो नहीं हुआ, किसी वजह से नहीं हुआ। आज जो इंडिया जो 1947 में सेक्युलर डेमोक्रेटिक रिपब्लिक बना, उसमें आप वो बात कहां से लाते हैं? और अगर हुआ भी होगा तो क्या उसका रिलेवेंस है? देयर इज अ लॉ ऑफ लिमिटेशन। आज मैं बोलूंगा 300 साल पहले मेरे दादा की जमीन थी और मुझे अभी ये हक चाहिए, तो मेरे को कोर्ट 2 मिनट में बाहर उड़ा देती है। आई विल नॉट कॉमेंट ऑन द कोर्ट डिसीजन, बट आई एग्री कि अयोध्या का जो डिसीजन, ये मेरा पर्सनल व्यू है, जो जजमेंट हुआ है उसके ऊपर कॉमेंट करना इसमें कोई गलत नहीं है। अकॉर्डिंग टू मी वो एक समझौता उन्होंने निकाला है वो जजमेंट में, लेकिन माना गया है कि आइडॉल्स आपने जबरदस्ती घुसाए 1949 में। तो ये जो जगह है अभी भी जो शिवलिंग बोलते, एक और भी बात है, कई बार क्या होता था, ये जो डिमोलिश करके जो बनाते थे मतलब मंदिर या मस्जिद, उसमें वो डिमोलिश्ड मटेरियल यूज किया जाता था। तो उसमें भी हो सकता है कि अगर पहले मंदिर था तो उस पर कोई उसके जो पत्थर है उस पर कुछ निशानी है, वही यूज किए गए, ऐसा हो सकता है। नीचे डंपिंग होता है। या बनाने वाले कारागिर ये हिंदू रहते तो कोई कुछ बना सकता है उधर बनाते समय। तो ये बातें कॉन्क्लूसिव नहीं है। और मैं जैसा मैंने बोला, मैं बोलता हूँ ये भी छोड़ो, अगर बनाया भी है तो आज क्या आपको हक मिलता है क्या कि वो तोड़ो? एक आपको लॉ जिनको मालूम नहीं उनको मैं बोलता हूँ, बाकी उनको तो मालूम है। एक ट्रेसपासर भी जगह का ओनर बन जाता है। ये मालूम है कि आपको 20 साल के बाद ट्रेसपासर जिसको कुछ राइट नहीं है वो ओनर बन जाता है, क्योंकि लॉ पुराने बातें नहीं निकालना चाहता। एक लिमिटेशन स्टैट्यूट है। 20 साल के बाद आपको मालूम नहीं, अगर ट्रेसपासर होगा तो 20 साल अनइंटरप्टेड पोजीशन में ओपनली रहा तो ही बिकम्स एन ओनर। 20 years that was possession. Again, government property it is 60 years, क्योंकि गवर्नमेंट को थोड़ा टाइम लगता है। तो 60 years के बाद वो ओनर हो जाता है। तो ये लॉ की पॉलिसी है। तो अगर तोड़ा भी होगा तो क्या आज उसका आप निराकरण कर सकते हैं? बोलते हो मेरा राइट अभी चला गया वो राइट, अब वो नहीं तो हमेशा अनसेटल्ड रहेगा ये सब। मैं कहूंगा अच्छा उसके पहले क्या था मंदिर के हमको मालूम नहीं है, हो सकता है कि जैसे फादर ने बोला कोई वो पुराने कम्युनिटी की कोई होगी निशानी, तो उसका क्या हल निकालेंगे आप? तो ये सब अननेसेसरी डिस्प्यूट है, ये सब मोटिवेटेड है। मुझे स्टडी करने को मौका नहीं मिला, मैं दूसरे काम में था, लेकिन वो प्लेंट और ये मैंने देखा नहीं है, इसलिए मैं ज्यादा कुछ नहीं कहूंगा प्लेंट क्या है वो। लेकिन जहां तक मेरा नॉलेज है सिंपल राइट टू वर्शिप देयर इज नो सिविल राइट। अपने पास प्रोफेसर है, आई थिंक देयर शुड बी अ क्लेम फॉर अटैचमेंट टू एन ऑफिस और सम इमोल्यूमेंट्स या ऐसा कुछ होना चाहिए टाइटल, तो इट्स अ सिविल सूट इज मेंटेनेबल। ये मेरा कहना है, मेरा मानना है, मैं स्टडी करूंगा इसके बारे में। और मुझे प्रेयर मालूम नहीं है, सिर्फ इस जगह पे मुझे प्रेयर करने का हक है, ये सिविल राइट है कि नहीं ये भी आई डाउट। नाउ द प्रोफेसर इज टेलिंग दैट इट इज नॉट। आई वुड डू द रिसर्च बिकॉज आई नेवर फॉरगेट वंस आई रीड, आई हैव रेड समवेयर दैट अ mere राइट टू वर्शिप इज नॉट अ सिविल राइट। तो उनके प्लेंट भी देखना पड़ेगा, क्योंकि जो प्रेस में आ रहा है उससे ऐसा लगा है कि दे आर क्लेमिंग अ राइट टू वर्शिप, तो ये राइट तो सिविल राइट है कि नहीं, यहां से शुरुआत है, फिर इट इज बार्ड बाय दैट। एक मैं कहूंगा कि जो जब कोर्ट के जुरिस्डिक्शन को ऑब्जेक्शन लिया जाता है कि सूट मेंटेनेबल नहीं है, तो फर्स्ट दैट ऑब्जेक्शन शुड बी डिसाइडेड। इट्स नॉट ओनली अ मैटर ऑफ लॉ बट इट इज अ मैटर ऑफ कॉमन सेंस ऑल्सो। आप उसमें सब इंटरिम ऑर्डर पास करोगे, एविडेंस रखा करें और बाद में बोलोगे सूट मेंटेनेबल नहीं है, तो ये इट्स अ मैटर ऑफ कॉमन सेंस दैट सच एप्लीकेशन नीड्स टू बी डिसाइडेड वेरी एक्सपीडिशियसली एंड फर्स्ट। So friends, this is my evaluation and this is the legal aspect of that matter as far as we can discuss, because the matters are pending. Let us hope that there will be the law will be more rational and properly the matter will be argued before the Supreme Court and legally sound tenable decision in tune with the constitutional provisions will come. There is no doubt there is no reason to doubt that this will happen. Thank you very much. Thank you.